See, Mr. Radford, you have Michelle Cormier, 25 DCCR 0153.
Yes, ma'am. He used to be custody.
Morning.
Mr. Coleman's case. I think he's in trial. Isn't
He is. Somebody handle this for Mr. Coleman.
Yes, Judge, we got stuff.
he? Hello, Michelle.
Good morning, ma'am. Are you Michelle Cormier?
Yes, ma'am.
And Ms. Cormier is charged with the offense of murder in cause number 250153. And Mr. Radford, what is the announcement?
Judge, I have a conference next week with my expert in this case that will give me insight as to where we go from here. I should be able to announce if I have one more.
Okay. Any notes or issues from Mr. Coleman? So we'll reset it one more time to give you an opportunity to do that, and then we'll get an announcement at that next court
I'll be
date.
ready then.
All right, thank you. You can go back with the bailiff. Mr. Rojas, you've got, yes, sir. Bryce Bordeaux, 250444. Good morning.
Good morning.
Sorry, am I messing you up now? You can put it in because it goes.
Good morning.
Good morning.
He's asking for a reset on that case, he was just hired on, so Gabe will stand up and work stuff.
Okay. We're going to reset Gabriel Smith. It was Mr. Rojas's, but Mr. Kimler's been hired.
Yes.
Good morning, sir. Are you Bryce Bordeaux?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the indictment?
Here we are.
Mr. Bordeaux, you're charged with the second-degree felony offense of robbery, and that's from March 18th of 2025, and that's cause number 250444. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state's marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 10-year deferred probation. There would be a $500 fine, and then we would wait for the PSI and see if there was any type of recommendation for safe P or treatment, and then I would make that determination. Is that your understanding? Also, do you understand, if you are not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Bordeaux is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent, you understand the nature and the consequences of that plea, find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. Then we'll come back at a later date for sentencing. All right, thank you, sir. You can go back with the bailiff.
That's all I have.
Yes, sir, thank you. Oh. Okay. Mr. Nix,
Yes, Your Honor.
you've got Michelle LaChasse.
Yes, Your Honor.
That's all that stuff. Good morning.
Good morning. How are you, Judge?
Good. Good morning. Good morning, ma'am. Are you Michelle LaChasse? And this is cause number 22-39304. Ms. LaChasse is on probation for abandoning or endangering a child. It's a state jail felony. And that probation was for a 3-year deferred probation, October 17th of 2022. Has that been extended? Okay. So obviously, we'll see what we do today, but if there's going to be safety, I think that would be a requirement for me to do that. So I received an administrative hearing on April 30th from Mr. Ruiz with some issues that have been going on with regard to Ms. LaChasse allegedly going to the Sky Bar Lounge, failing to adhere to the curfew, failing to adhere to mental health services and treatment plans, remaining compliant with medication, admitting to drinking, and also admitting to trying to locate drugs as well. That hearing recommendation was to continue supervision and request SafeP, which was agreed at the time by Ms. LaChasse. I signed off on that and ordered it. Mr. Nix has filed a motion asking that I reconsider that. I have asked probation for kind of an update in their response to that, as well as the state, who said pretty much it's up to me and probation and everything else. So it's my understanding, Mr. Nix, that Ms. LaChasse is wanting to do some kind of local inpatient treatment.
So Your Honor, if I could briefly just kind of give a little bit of a recap. She had her medication switched on March 11th and March the 20th. And shortly after that, if I can present this, I've shown a copy to the district attorney's office this morning. It showed that they made a major medication change, took her off Seroquel, put her on Prozac. She immediately started having issues with the Prozac. She's still having issues with the Prozac. She's taking the Prozac at the jail. They're giving it to her. She's having issues. What we've done is we've spoke to Baptist hospitals. I have her mother and I have her fiance here. We have documentation that she would be accepted into inpatient at Baptist Hospital. Also have a letter from her doctor.
But that's just a 5 to 7 days.
No, they can actually keep her inpatient for up to 30 days, Judge, and then they have an outpatient program that can continue after that. If I could present this is a letter from her doctor that kind of underlines her very exacerbated issues. What I'm asking the court to do is not to exactly undo the SafeP. What I'm asking the court to do is hold the SafeP in abeyance, give her a chance to do the inpatient Baptist, make sure that she's on the right medication. I presume that a major medication change is about to take place due to the fact that she's having such issues with the Prozac, and we reconvene after she's completed an inpatient stay. Whether it be 14 days, whether it be 30 days, I'm assuming it'll be 30 days based on what the fiance's talked to with Baptist. It would come at no cost to the taxpayer or to probation. We've already cleared it with her insurance. She's stayed there before, and insurance covered almost 100%. I'm asking the court to just hold the SafeP in abeyance until she can do the inpatient treatment. We reconvene in 30 days and see how she did in the inpatient treatment. And then depending on how the reports go, how everything that I turn over from her inpatient stay to both probation, the state, and the court, you decide if SafeP is still in her actual best interest at this point. We understand that SafeP is also a blessing. She could have been sentenced to state jail time. We're not underscoring the issues. We're explaining to the court that this is a mental health issue caused by a major medication change that's documented. Her issues follow immediately after this. And she's still on the Prozac, and she's still having lots of problems in the jail on the Prozac. We're asking that we just hold this in abeyance. I'm not asking the court to undo it, take it away, put her back on regular probation. I'm not asking for that. I'm asking to hold it in abeyance, place her, allow her to be placed in the inpatient.
But do we know, is it up to the hospital how long she stays?
I believe so, Your
I can't
Honor.
order some
Correct.
certain amount of
Correct.
time.
And however long that is, if the court feels that it's not long enough, we can reconvene and I can show you the records at that point and we can make a decision from there. But Baptist has told the family that it would be up to 30 days and then they have an outpatient treatment that can continue after that. Now, of course, we won't know if that's appropriate until we see how she does in there, but it's pretty clear that this is a medication change that caused this behavior.
Mr. Nichols?
Judge, part of the main hesitation on our part is that she agreed to SafeP and now wants to do things on her terms. I think SafeP is where she needs to be based on the relapse and the violation she had. And I want to bring the court's attention, when she was first put on probation in 2022, she was ordered ISF. Didn't want to go, went to a private inpatient program in Houston, in Harris County, which she was discharged unsuccessfully from. So it's almost like we're rewinding the same script as before, and it obviously didn't work then.
I didn't see that.
I don't think it's contained in the admin. I think Mr. Ruiz can testify to that, though, Your Honor, if you want more detail. He informed me about that this morning.
Okay. Do you have any disagreement with regard to what happened at the beginning of probation that they're talking about, Mr. Nix?
I'm not sure that I was a part
You were a part
of that, so I don't know that I can speak to that. What I can speak to is that they made a major medication change that immediately caused these issues. SafeP is a wonderful program that's helped a lot of people. I don't know that it's fine-tuned for her mental health issues that are causing the issues right now. I think it's a fantastic program, and I still think she might end up there, but I think if we get her the right mental health treatment, get her on the right medication, she's much more likely to be successful in SafeP if she has the right medication and she is of the right frame of mind.
The special needs SafeP facility, do they adjust medications and things like that? Yeah. I think based on what I know now from the beginning that I ordered or agreed or whatever happened with ISF, and then agreed to allow her not to do what everybody else thought was appropriate, go to her own choice, and successfully discharged from that, and here we are having the same problem. So I'm not going to adjust that order.
Yes, ma'am.
I am going to order the special needs. It's special needs SafeP. It's not the regular one. It is, the whole purpose of it is to treat both things. And so that can all take place there, and I think that would be better for her and for our community. In addition, I am going to, because of the issues in the administrative hearing, the fact that a motion hasn't been filed, the length of time, I think, obviously is an issue. And so I am going to also at this time order that Ms. LaChasse's probation be extended by 2 years. That should give plenty of time to get through the program, get through aftercare, make sure everything is going like it should be, and then hopefully get off this probation without a conviction or going to state jail. All right, I know it's not what you want. I hope you take advantage of it. However, it's a good program. You can talk to them about medications and get stabilized before you get out and get on aftercare. Okay, thank you, Mr.
Thank you,
Nix.
Judge.
Thank you,
Thank you,
Your
Mr. Ruiz, for being here as well. There's really not I think all that's probably can be thrown away. Mr. Nix, you also have Ebony Broussard. 3 cases. There is no paperwork or agreement on this, or?
We've got something cooking.
Okay,
So, Your Honor, Ms. Malfino.
let's wait for
I'm
Ms.
sorry.
Broussard. That's okay. Good morning, ma'am. Are you Ebony Broussard?
Yes.
And Ms. Broussard is on probation in cause numbers 19-32518, 19-32806, and 21-36615 for the offenses of escape while arrested, assault on a peace officer in possession of a controlled substance. There's been motion to revoke filed in all three of those cases. And Mr. Nix, what is the announcement?
Your Honor, I've spoken with the state. I think we have something in the works. I think we'd both like a 2-week reset. And I think in 2 weeks, some offers that we made to the state to try to resolve these issues will be made whole at that time. And I think this will be worked out at the 2-week reset.
Any issue, Ms. Malfino?
Judge, I have spoken at length with Ms. Johnson, who has worked with this defendant for a long time now. Of course, respect her position ultimately in that she is the one who actually works with her. There are quite a bit of arrears due in this case. Ms. Broussard has been ordered previously to pay those with forms of income such as her tax return, et cetera. She has been defiant in doing that to the probation department. Mr. Nix indicates that she, via her family while she remains in custody, is able to do that in the next 2 weeks, and I'd like to reconvene at that time to maybe see where we are. Our position in the alternative will probably be ISF cognitive. In fact, if she does not get that paid, we may just go ahead and proceed with the motion. We'll be ready to do it on that day.
Okay, sounds good. Thank you for being here, Ms. Johnson. We'll reset the case for 2 weeks.
Thank you, Judge.
Thank you. Ma'am, you need to remove your hat, or you need to remove your hat. Or sir, I can't tell, I can't see your face, whoever.
Check your phones, make sure that they're in off position.
See,
If
Mr.
you disturb us, you be asked to leave the courtroom.
Thank you. Mr. Burbank, you've got Jerry Jenkins.
Judge, before we bring him out, may we just discuss with the court?
Yeah, let's hold on. Both ready on Jerry Jenkins if there's not some agreement.
Yes, Your Honor, you would expect to be number one.
Okay, Mr. Burbank?
I always expect to be number one, Your Honor.
Okay.
Just due to the age.
So, yeah, it's definitely, so I'm gonna, wait to hear from y'all. I would make it as early in the morning as possible, you know, before 10 o'clock, because we'll have to get both of you over
I
here.
can be here at 6:30 in the morning. Before you pick.
Let's do it. Don't dare me. So, yeah, let me know and then we'll work that out tomorrow. Otherwise, it will be numbered, so we don't need Mr. Jenkins. Mr. Burbank, what about, do you want to go ahead and announce on Terry Rose?
Yeah, we could, Judge. Somebody get Ms. Rose?
Yeah. I know. It's our first day. You could video. Oh, no, no one asked.
Okay, I'm just making sure.
Was that one, the one that just left? Okay. Good morning. Are you Terry Rose?
Yes, ma'am.
And Mr. Rose, in cause number 241369, is charged with the offense of murder. There was a request for a competency evaluation that was done by Dr. Grapon. I'm going to take judicial notice of the court's file. We have received that evaluation dated May 23rd of 2025. Dr. Grapon, after that evaluation, makes the finding that Mr. Rose is currently competent to stand trial. Is there any other evidence with regard to competency? Mr. Burbank?
Defense, Judge. No, Your Honor.
Then at this time, I am going to find that Mr. Rose is competent to stand trial. Mr. Burbank, announcement?
Your Honor, as you are well aware, I'm the second one.
Right.
I just need one more announcement, 30 days or 40 days. and we may be able to.
Okay. Any issue with that, Mr. Nichols?
No, Your Honor, we're just, state's ready to proceed.
And I appreciate you getting up to speed as quickly as possible. Looks like we've got an investigator involved and you've taken care of that,
We do,
so.
and I was out, I provided him information, and he's helping me with this, and so once I cover all my bases and get up to see the district attorney, we'll be able to take care of this now.
All right, what I'll do to make sure your investigator, you have plenty of time to get up to speed, is reset it 45 days and expect an announcement on that date.
Thank you.
All right?
Maybe
Thank you.
excuse to that time.
Yes, sir.
Thank you, Judge.
Do you want to go ahead and take care of Bryce Thomas and then visit? Okay. Bryce Thomas,
Your Honor, we're
would
going
y'all,
open.
hold on a second. Are y'all pleading to the indictments? Are there some
There's-
lessers? And
yes,
can I
there's-
get all four of those, please, printed out?
The unauthorized use is being dismissed.
Give me just a second while they print out the ones that are being, just the four that he's pleading on. I need,
Got these right here. if that's what you need.
everything, all of them except 0534. Good morning. Are you Bryce Thomas? And Mr. Burbank, will your client waive the formal reading of the indictment in each case?
Yes, Your Honor. We're going open on each case, and the aggravated sexual assault is being the lesser included indecency by exposure, which is a third degree.
So is,
Did you sign it? Did not.
we can do it. Y'all can get it done as soon as I'm finished. I'll go.
Completely about the registration.
I'll go through it with them. I just want to make sure, because of the agreement for the lesser in that case and for anything to run concurrently, is that the plea bargain agreement where he would be waiving his right to appeal?
And also they're
The dismissal.
dismissing the UUMB.
Gotcha. Okay. Give me just a second. Yeah.
And the lesser included is December 1st, as a
Third. Oh, 0354's been dismissed, I think. Or 0534, whatever I said. Okay, Mr. Thomas, in cause number 24, DCCR 0389, you're charged with a third-degree felony offense of possession of a prohibited weapon from January 31st of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? In cause number 24-0390, you're charged with a third-degree felony offense of possession of a prohibited weapon from January 30th of 2024. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? In cause number 24 DCCR 0391, you're charged with a state jail felony offense of theft of a firearm, and that's from January 30th of 2024. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with? And then what is the reduction to?
It's indecency exposure for a degree felony.
In cause number 24, DCCR 0392, the state has elected to proceed on the lesser included offense of a third-degree felony of indecency with a child by exposure, and that's from November 9th of 2023. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily, and because you did what they charged you with? In each of these cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Burbank? Do you fully understand them? And I want to make sure you understand there's kind of a partial agreement, and that agreement is that the state is going to dismiss cause number 240534, which is an unauthorized use of a vehicle. They are agreeing to that lesser included offense of the indecency in that case. And they're also agreeing that if anything that I sentence you to, if it's time in prison, would run concurrently. There's not a specific agreement with regard to any time or any outcome, only those agreements with regard to the dismissal of the case, the reduction in the other case, and the fact that they'll all run at the same time. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? Also, in that indecency case, do you understand that you will be required to register as a sex offender? And Mr. Burbank will go over that more with you today, and there's a document you need to sign today with regard to that. And do you understand that as well? State tenders number 1 in each case.
No objection. States 1 in each case, Your Honor.
It's admitted in each case. Is there any evidence that Mr. Thomas is not competent?
No, Your Honor.
All right, sir, I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence in each of your cases to find you guilty. However, I'm going to reset your case for a sentencing hearing. We'll get a pre-sentence report done. That'll give me more information about you, your cases, and we'll come back later for sentencing. Anything that you think is important for me to know, make sure you get that information to Mr. Burbank. He will present it to me on your behalf when we come back. All right? You can go back with the bailiff.
May be excused a minute.
Yes, sir. And I'll give you a minute to talk to
Can
Mr.
someone
Ramon.
Send it back to a computer.
Send what back?
I think we have to send back so I can do the admonishment for the sex offender. I know, but can I get back into it?
In the case, I think you can.
Okay.
Just get back into that case, I think you can.
And I'm going to go
Oh,
out.
she's gonna send it. Yeah, make sure they don't take Mr. Thomas yet until Mr. Burbank goes over. He's got to sign one more paper. Thank you, ma'am.
Will you send that back to
Is Mr. Franklin here? Good morning. That's on Juan Sanchez. This is, good morning, 1830854. How are you today?
Just fine, how are you?
Good, thank you.
So, yeah.
Anna, what were you asking?
You said, Lawrence Thomas, 392 about President Burbank.
Good morning. Are you Juan David Sanchez? And Mr. Sanchez is currently on probation for the offense of driving while intoxicated, third or more. A motion to revoke was filed with the allegation that there was a new offense of driving while intoxicated from April 15th of this year in Wharton. Is that Wharton County or, anyway, it's in Texas. And then also that on April 15th, 2025, he was driving a vehicle that was not equipped with an ignition interlock device, and that he failed to abstain from the use of alcohol. Mr. Franklin has filed a motion asking that I set a bond. There's currently not a bond on the motion to revoke probation. Do you intend to call your client as a witness or no? Or,
Only if necessary, Your Honor.
go ahead and I'm trying to find, give me just a second. I'm looking for the old PSI.
I have my copy if you need it, Your Honor.
This one may be old enough where it didn't get,
It may be so old, but back then they probably weren't.
It was 2019.
okay. All right, you can go ahead, Mr.
Your Honor, we have
Franklin.
not been provided with a copy of the old PSI. That was not produced to us. So that was one of the issues I think that needs addressing. We also supplied
Mr. Nichols,
right up, I'm sorry.
go ahead.
We supplied, we filed with our motion about a dozen letters in support.
And I have received those and take judicial notice of the court's file that includes those as well. Thank you.
Thank you, Your Honor. In assessing whether Mr. Sanchez is a flight risk, I think the support from his community, from his family, helped provide evidence that he's not a flight risk. So the court should then turn to the prong of whether, of what threat he may pose to himself or others. In this case, the underlying offense was 2019. The motion was filed based on a violation, true, but there were not other violations as far as not reporting or failing other tests up until now. So that's been effectively 6 years that he's been compliant. We'd also like for the court to take note that the other offenses that are mentioned go back as far as 1992 to 1995, 2001, et cetera. In other words, it has been, in some instances, decades since those offenses occurred. And although we're not downplaying the severity of what Mr. Sanchez is currently charged with, we do think the court should take into account, as regards the threat to himself or others, the fact that the other causes are, in some instances, over 30 years old.
What's the status of that case in Wharton? Does anybody know?
Your Honor, it is my understanding, and I don't represent him on that case, but my understanding is that it is pending because this one fell first in the queue, so he was sent here first.
Okay. So they're going to wait for us to see what I do, I
That
guess.
is my understanding, Your Honor, but again, I don't represent him on that, but that's what I could glean. I spoke to a lawyer that he conferred with there, but he did not end up hiring that lawyer, so he couldn't speak,
Okay. All right, Mr. Nichols, what's the state's position with regard to a bond?
Judge, my main concern is him driving a vehicle that doesn't have an interlock. We have no idea how much driving he's done. It sounds like the only reason we found out about this violation is that he got caught. I doubt that this is a one-time event of driving his wife's vehicle without an interlock. And so to protect the community, I'd ask that if the court does set a bond, that it be high enough to protect the community from this repeated driving while intoxicated.
Your Honor, may I respond?
Sure.
First, speculation as regards any other instances is probably not admissible. But secondly, there are measures that the court can take in assigning bond conditions to monitor Mr. Sanchez in such a way that he...
But he had probation conditions that were meant to monitor him.
Your Honor, as regards whether he's drinking, for example, there are SCRAM devices and other devices
Yeah.
that constantly test for alcohol in the system. The SCRAM device, for example, tests every half hour.
Yeah, so here's where I am on this. Mr. Sanchez had at least, this is his fourth conviction that we know of for a DUI. I know there were some other arrests that we didn't have the disposition. Looks like, at least according to some of the information I've received, that there's been 7 or 8 arrests. This
We would
was a
object to
cap.
including those as well, Your Honor.
Okay, that's overruled. think with regard to setting bond, under 17.15, I'm able to take into consideration everything that is at my disposal. And in fact, I'm required to take into account everything that is at my disposal with regard to prior offenses, with the most recent bail reform, as well as the ones from a couple years ago. So I guess my worry isn't necessarily the reporting or him fleeing. My concern is for the safety of the community. And this was a cap of 8 years when I gave him this probation, probably against the argument of counsel from the state, and gave him this opportunity. He's on probation, commits another. We're lucky we're not here for an intox assault or even worse. I am going to deny the motion for a bond at this time. If there is any likelihood at all that I would leave Mr. Sanchez on probation, it would absolutely be with some type of treatment. And so I'm not going to allow him to get out and even with the scram or anything else and put the community in danger. All right, we'll get it set for an announcement within about 30 days or so, and then we'll see where we get on the case.
Thank you, Judge.
Thank you, sir. You can go back with the bailiff.
Your Honor, may I be excused?
Yes, sir, thank you. Oh, that's okay. Got it. Today's the 10th. See, is Mr. LeBlanc? Oh, good morning, Mr. LeBlanc. You've got Linton Arsenault. Are you ready to make?
The prosecutor's, COVID, he's not here, and I need to talk to him about something, so I don't know.
Okay. Is there something, Mr. Hoppower is not available this
No,
morning?
no, Your Honor, he's not in this morning.
Did you try to visit with him before today?
Yeah, we talked, and Brady had another room here. We talked yesterday.
All right, I'm going to reset Mr. Arsenault for 2 weeks to give Mr. LeBlanc some time to visit with Mr. Hoppower again. Make sure you visit with him before that next court date, just in case something happens, and that way he can make some notes for the district attorney. All right, you can go back with the bailiff. You've got Corey Flemings.
Yeah, can I have 1 moment?
Sure.
Your Honor, Madam Clerk,
Sure.
I just sent the registration if you wanted to go over at sentencing with them.
I don't really have to. I just need it signed by him. Thank you very much. I see it just came through. Mr. Cole, you've got Leonard Eilbird.
Yes, Your Honor.
Oh, that's just setting a hearing.
Oh, I have. And didn't send me an order.
Okay. Okay, that's okay. I might write on. Let me see what I'll need something. Good morning, Mr. Cole.
Good morning, y'all. How you doing?
Good. How about you?
Great, great, great.
All right. Are you Leonard Dale Adelbird?
Yes.
And this is cause number 1625968. Mr. Adelbird is on probation for driving while intoxicated, third or more. A motion to revoke has been filed, and Mr. Cole has filed a motion asking that I set a bond in this case.
Yes, sir.
And it looks like the allegations from that motion are that Mr. Adelbird, while on probation, allegedly committed the new offense of driving while intoxicated, third or more, January 9th of 2025 in Chambers County, Texas. That he left Jefferson County without permission. That he drove a vehicle that did not have an interlock device on it. That when he was stopped, the allegation is the intoxilizer that was administered provided breath samples of .108 and .115 and behind in his fees a little bit as well. Mr. Cole?
Well, Your Honor, I think since the time that Mr. Otterberg was put on probation in 2017, up until this latest incident, his mental capacity has changed dramatically. He's been diagnosed with Alzheimer's. He's on the verge of his nerves inside of his brain have shrunk. So on top of the Alzheimer's, he's has the possibility of having a stroke. So I think that this is him not remembering the conditions, and his wife is here that can, his keys, you're taking his keys. We do have paperwork that I gave to counsel that can, from the doctor showing that he does have Alzheimer's. He was diagnosed in March with Alzheimer's, and the nerves in his brain are shrinking. Your Honor, he's unaware that he even violated the condition.
Well, that makes it even scarier for me.
That I know it does, but we're asking that we get him out, and his wife is gonna take care of him and make sure that he doesn't drive that car anymore. Take the keys, now that we're aware of.
Why don't you, if you want to put on a witness, that might help.
I'd like to call Gwendolyn Brown, please.
Okay, Ms. Brown, come on up, ma'am. Do you have some documentation? Good morning, ma'am. And your name, what was your first name?
Gwendolyn,
Gwendolyn Brown. And Ms. Brown, would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
yes, ma'am.
Thank you. Go ahead, Mr. Cole.
State your name for the record, ma'am.
Gwendolyn and Albert.
Yes, ma'am. And how long have you known this gentleman right here?
We've been married 13 years.
13 years. And when did you start noticing deterioration in his mental capacity?
Back in December last month,
December.
last year, 2004.
And I guess another question I want to ask you is,
Can you speak up, please?
what are you willing to do to ensure that Mr. Otterberg no longer has access to his vehicle?
I will take the keys from him. He will not drive anymore. Nothing.
He already had it.
I already had the keys. He can't drive anymore. He will not drive anymore.
That's her car. That's her car.
Oh, I'm sorry.
So, he will not drive anymore. I will take the keys from him, and he will not drive.
And do you think that in this situation that happened in Chambers County, do you think that he was aware of the conditions of probation that he was violating?
No, he wasn't aware because his probation officer told him that she was done with him. So when you say you're done with somebody, that means you're done with them. You thought he wasn't on probation anymore.
So there's a lot going on upstairs, Your Honor. I don't want him showing back up in a red suit. I know she didn't care for him outside of this facility that he's currently in right now, which is in jail. We have a court case in Chambers County that we would like to be at. And I don't think that he was intentionally violating probation. I think that he, at this point, his mind is.
He get lost all the time.
Yes. So he's getting lost. He doesn't know whether he's coming or going. And I can have a conversation with him right now, and he'll forget it in the next 2 hours. So, it's one of the
Thank you,
things-
ma'am. You can have a seat.
I just want to say one more thing.
Yes, ma'am.
When he was in jail in Chambers County, the probation officer told me to bring him to her as soon as I get him out of jail, right? So I brought him to her, and then she called his name, and I was going upstairs with him, and she said, "Miss Otterberg, you have to stay downstairs." So she went, she said, "Only me and my supervisor need to talk to him." So the supervisor talked to him, and when he came back outside, I said, "What did she say?" He said, "Nothing." She said, "Go home." But she had told him to go turn himself in to Jefferson County.
Okay,
He didn't remember by the time he got back to the car.
okay,
So he would have been in jail.
right. Thank you, ma'am. Ms. Malfino, based on,
Obviously, I have the same concerns, the court, based on the representation of his wife, that he won't be driving. That gives me a little bit of comfort. I did speak myself with Ms. Hunter. I know she's probably just told him what the rules are, and maybe he doesn't understand them, but I know she hasn't been combative with him. She initially told me she doesn't oppose him being a bond. I don't know if she's aware of these medical conditions, but again, I'm concerned with the driving factor. And obviously, you couldn't go somewhere like mental health, safety, or anything with that.
no, not with that diagnosis, or not, and I don't think with that diagnosis either.
Right.
Let me look at something else. All right, so what I'm going to do in this case is set a bond. I'm going to set the bond at $5,000. I'm going to order that a condition of that bond is that Mr. Idlebird not drive ever. And I'm doing that on the representation that the keys will be taken away, hidden, whatever's necessary. And so I'm looking at you, ma'am, that you are giving me that representation to make me feel comfortable that he doesn't get the keys somehow and drive. So just sticking them in your purse or sticking them in a drawer with this type of diagnosis is not going to be good enough. I'm going with your assurances that you're going to take care of that. Obviously, you don't want anything to happen to anyone else in the community as much as I don't. So I'm going to do this based on the fact that you're giving me those assurances. And then obviously there will not need to be, if there's already an order for an interlock, I will allow that to be. Is there an interlock?
Yes, Your Honor.
Yes.
But he's done.
Well, I know we want him to be done and we're saying he's done. You're able to drive the vehicle with the interlock, correct?
I can't breathe. You talking about breathing?
Y'all don't have, how many cars do y'all have?
I have one car.
Okay,
His car is gone.
it's gone.
Right.
Okay, so I won't require an interlock on her vehicle, so that, if he doesn't have, if that's gone, then we're fine with that. Any other condition other than the no driving and her assurances that you can think of, Ms. Malfino?
No, Your Honor.
Okay, all right, we'll reset it for an announcement on that, MTRP.
Well, may I just inquire, Judge, before that hearing, is it Mr. Giles, Mr. Cole, your representation to the court that you believe at some point in time, your client will be able to enter pleas of either true or not true to this motion, or do we need to make some other type of arrangements? Can you?
I believe that he'll be able to make pleas are true or not true.
Okay.
Yes.
Once you have more time to visit with him as well, if there's an issue because of the diagnosis with regard to competency, we might have to try to just see where we are on it all, okay? All right,
Thank you.
thank you. You can go back with the bailiff.
Okay.
My excuse, Your Honor.
Yes, sir. Mr. Wilkerson, you have Shanna King. Is today your birthday? Happy birthday.
Thank you. Thank you all very much.
I would sing, but you don't want me to do that. Trust me. The gift is that I'm not going to.
I say the same thing to people. I can't do it. Love to do it, but
Yeah.
every now and then I torment people at nightclubs with a little karaoke spill.
Okay. Y'all have got second and third marked off on this.
So, Judge, the tablets won't let us erase.
Oh.
So
You have to push the
I
button.
tried both buttons and.
So it should be second.
It's a second.
It's a
Okay,
second.
I got it.
Yes.
All right,
Sorry.
ma'am, that's okay. Are you Shanna King?
Yes, ma'am.
And Mr. Wilkerson, will your client waive the formal reading of the indictment?
Yes, Your Honor.
Ms. King, in cause number 250295, you're charged with the second-degree felony offense of burglary of a habitation, and that's from December 13th of 2024. And how do you plead to that charge?
Guilty, ma'am.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state's marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Wilkerson?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. King is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of that plea, find sufficient evidence to find you guilty, and at this time find you guilty of burglary of a habitation, sentence you in accordance with your agreement to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification. That shows that this was an agreement that I followed, and so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Wilkerson. All right, good luck to you, ma'am. You go back with the bailiff.
Go take this with me? Okay, thank y'all.
Thank you.
Your Honor. Be excused.
Yes, sir. Mr. Burbank, are you ready on the sentencing on Johnny Jacobo Ramon?
We are.
Good morning, ma'am. Would you, Ms. Burge, would you please raise your right hand? Do you swear or affirm that you will truthfully and accurately translate from English to Spanish and Spanish to English, so help you God? Thank you. Good morning. Are you Johnny Jacobo Ramon?
Yes.
And Mr. Ramon, you were previously in court and entered a plea of guilty to the second-degree felony offense of accident involving death. And that was a plea agreement of a cap of 15 years in prison. I have received the pre-sentence report. Has everyone had an opportunity to review that report?
Defense has.
Yes, Judge.
Are there any additions or corrections?
No, Your Honor.
Understood.
Mr. Burbank, you may proceed.
Your Honor, this is a tragic accident. If you read the factual basis, which I know you did, person was walking across the street at nighttime, and cars swerved, and my client actually hit him. As reflected by the charge, he failed to stop. He panicked, as in reference to his version, that is on page 1, and then was stopped up in Lumberton. He's been employed. He has family up in Woodville. He's been employed. He's got one problem. He is not a U.S. citizen. I would be arguing for probation in this case. but it is my understanding that there is a hold on him by immigration, and that he probably will not, if he got probation, he wouldn't be released. He has 2 prior DWIs from Tyler County that were taken care of. At the same time, what you receive, basically time served, 90 days jail. The intoxication charge that I believe is from Hardin County was when he was arrested, and that's been dismissed or rejected by the, and probably because we're down here, they probably did it. Your Honor, I asked for not, there's a death involved, and I would love to have the minimum in reference to penitentiary time, but I'm asking for mid. I think that 15 is probably too harsh, and that's my opinion, especially in light of the facts and circumstances of this, in which the person was walking across the street at the time and being blocked by other vehicles, and other vehicles had to get out of the way. But he was definitely wrong in not stopping, and he was intoxicated. I would ask for anything less than the 15, because I know where he's gonna go, and that's a sad thing, but he's not here legally. And I don't know if he would like to address the court.
Sí.
Yes, sí.
Go ahead.
Quiero decir que lo siento, que si lo hubiese visto, yo me hubiese detenido antes para poder auxiliarlo, pero pues...
Hold on.
Judge, I'm so sorry. Had I seen him, I would have stopped and helped and rendered aid.
Pero pues había un carro con...
Hold on. Hold on. So are you telling me that you didn't know you hit someone?
¿Me están diciendo que usted no sabe que le pegó a alguien?
No, sí.
I didn't know.
Okay.
Y pero pues había un carro enfrente y yo no lo pude ver antes.
There was a vehicle in front and I wasn't able to see him on time.
Okay.
Pero pues quiero decir que lo siento.
I want to say that I'm sorry.
Que si pudiera volver el tiempo lo haría, pero...
But if I could go back in time, I would go back and
Soy el
help.
culpable.
And I know I'm guilty.
Okay. Thank you.
I just have one question up here. What were you doing for work?
¿Qué estaba haciendo de trabajo?
Estaba en el roofing.
I was a roofer.
And how long have you been in the country?
¿Cuánto tiempo has estado aquí en los Estados Unidos?
14, 15 años.
14, 15 years.
And have you always had a job?
¿Siempre han tenido un empleo?
Sí.
Yes.
And you do have a family?
¿Y si tienen una familia?
Sí.
Yes.
Thank you. Mr. Smith?
Judge, we would argue for the max sentence in this case on the plea agreement based on the fact that when he struck him, he knew that he struck him. That was evidenced by the phone calls. The next day, he knew he hit a person. When he was stopped in Koontz, which is a long way from the accident scene, he told the police when they noticed the damage on his vehicle that he had struck a deer. They, either through dealing with him before or suspecting that he was lying and knew he was intoxicated, went all the way back to the county line looking for a deer that had just been struck. And only because they were diligent in doing so did we even know that he had committed this particular crime. He knew he committed the crime. He lied about it. He has an issue with alcohol. He's here in the country illegally. I would direct your attention to the jail report in this case and how he's acting, showing disrespect for staff, as well as masturbating in open bunk. We ask for a 15-year sentence in this case.
Mr. Jacobo Ramon, obviously the facts of the case are terrible. The fact that you didn't stop. The fact that you were intoxicated. And in addition, and I'm not even sure that when you were in our jail for some amount of time, there was a requirement that I release you because of the amount of time that had gone from the time of the offense while you were sitting in custody. I did that, and then you didn't show up. You are here illegally and have now killed someone. I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. And at this time, find you guilty of accident involving death. Sentence you to 15 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. It is in Spanish. I advise you to read that. If you are ever back in Texas legally, you will not be able to possess a firearm or ammunition. That could lead to more charges against you. All right. Thank you. You can go back with the bailiff. Thank you, Mr. Burbank. Thank you, Ms. Burge. Mr. LeBlanc, are you ready on Corey Flemings?
Yes, sir.
Good morning, sir. You're Corey Flemings?
Yes, ma'am.
And Mr. Flemings has two cases, cause number 24-2144 and 24-2145, set for trial to begin with jury selection on Monday, the 23rd. And what is the announcement?
We'll be ready, Your Honor.
All right.
State's ready, as far as I'm aware, from Mr. Colvin, Judge, I would ask that Mr. LeBlanc make a request for the media if he has not done so already, since we have a bit of time in between.
Okay. Have you asked for and received the media?
I believe this is the one, yes, I've asked for it, but I haven't received it. I think I have it. I'll have to check if I have it, about all this, but
It's
when you're right.
okay.
Ready.
Well, but if your client hasn't seen the videos or any type of media with you, then how do you know for certain that this is what is the appropriate end game? Because he hasn't seen, I would assume in an assault on a peace officer, there's body cam footage that might affect what agreement there is. Do you know if that is, can that get ready today?
Yes, Judge, it doesn't look like it was marked as requested and received, but I can follow up on it.
I want that done today.
Yes, sir.
I want you out to see Mr. Flemings by tomorrow
Yes, sir.
to review that with him. And I want to know by tomorrow at noon that it has been done and that in fact this is what Mr. Flemings wants to do, is go to trial after seeing that. All right? I want to hear from you at noon tomorrow. Okay. You can go back with the bailiff. Done. Done. Mr. Lewis on Christopher Falk. And this was, he was evaluated.
He's valuable, he's competent.
Okay. Good morning. Are you Christopher Falk? And this is cause number 241891. Mr. Falk is charged with assault on a public servant. There was a request to have Mr. Falk examined for competency to stand trial. Dr. Grapan did that evaluation. I've received that report dated May 30th of 2025. It has the finding that Mr. Falk is currently competent to stand trial. Is there any other evidence with regard to competency?
Nothing to question.
No, Your Honor.
All right, then based on that, I am going to find at this time Mr. Falk competent to stand trial. And do you need some time for an announcement, or are y'all ready to make an announcement today?
A little more time, Judge. I have talked to him a little bit since we've gotten the report back, but I think we need to talk to state a little more and see if we can get it worked out.
All right, I'll reset that one more time, and then we'll see if we can get an announcement at the next court date. Is that your computer? That's okay.
Do I need to get the bailiff?
All right, we'll reset it. We'll get an announcement at the next court date. You can go back with the bailiff. And then you've got David Tillman, 2 cases.
And Judge, Kevin Train, he's coming up. This is one that me and Mr. I'm looking to talk about. We think we need to get him evaluated. And actually, one of the bailiffs had let me know they've had an issue with him this morning. So
Let's go ahead and also reset Mr. Tran. We'll have an evaluation done on him if y'all wanted to get that order that we have for that to be done. I'm thinking about something else. All right, sir, are you David Tillman?
Yes, ma'am.
And, all right, so it looks like there is we've got cause number 22-40540 and 24-0536. And will your client waive the formal reading of the motion and the indictment?
yes, ma'am.
Just a second to get there. Okay, Mr. Tillman, in cause number 240536, are we going on count 1 only?
Yeah, sure.
Yes, sure.
God bless you. The state has elected to proceed on count 1 only. It alleges you committed the first-degree felony offense of aggravated sexual assault of a child from August 15th of 2022. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they charged you with?
Yeah.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
And do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes.
Also, in this case, do you understand that you will be required to register as a sex offender? It looks like you've signed that paperwork, and have you gone over that with Mr. Lewis as well?
Yes.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number one.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Tillman is not competent?
No, Judge.
All right, Mr. Tillman, in cause number 240536, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of aggravated sexual assault of a child. Sentence you in accordance with your agreement to a term of 20 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Okay, and then,
And it's a little confusing, Your Honor. The motion does not contain that the offense he just pled guilty to because the dates, the new offense predates him being
Gotcha.
put on probation, so it's not
Okay.
part of the revocation.
gotcha, thank you. All right, and then in cause number 2240540, I have a motion to revoke your community supervision. Shows that you were placed on probation May 1st of 2023 for the offense of unlawful possession of a firearm by a felon, and that was a 10-year term in prison that was probated for 6 years. Is that correct?
Yes, ma'am, that's true.
And it alleges that you violated your probation. Count 1 alleges that you failed to provide verification of performing the community service hours as required. And is that true or not true?
That's true.
Count 2 alleges that you failed to provide verification of entering and successfully completing the MRT, the Moral Recognition Therapy Program. Is that true or not true?
That's true.
And then count 3 alleges that you are behind in your court-assessed fees. And is that true or not true?
That's true.
Did you enter your pleas of true to each of those counts freely and voluntarily?
Yes, ma'am.
And did you plead true because those counts are actually true?
Yeah, true.
I also have some documents here on the computer in that case that have your signature on them that the state's marked as exhibit number 1. Did you also go over these with Mr. Lewis?
Yes, ma'am.
And do you fully understand them as well?
Yes.
And do you understand, again, if I follow the agreement in this case, you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection, Judge.
It's admitted. All right, Mr. Tillman, I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time, revoke your probation. Sentence you to a term of 10 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These 2 cases will run concurrently, which means together at the same time. I'm handing you now, in each of your cases, the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. We already went over that when I put you on that probation. I just want to make sure you understand, based on the judgments in both of these cases, you are ineligible under Texas law to possess a firearm or ammunition. If you have any questions about that, make sure you read that document and talk to Mr. Lewis.
Yes, ma'am.
All right, good luck to you, sir. You can go back with the bailiff.
I have one question.
Yes, sir.
Does the time I get credit also include the time I was in Oklahoma?
So the time that you will get credit on is any time that you were either in our custody or that we had a hold on you. So if we had a hold on you from Jefferson County and you were in some other place being held, then yes, you would get that. If we did not have a hold on you, then you would not.
All right.
Okay?
Thank you.
Yes, sir. Jacqueline Young, Mr. Lewis.
basically, once he came out.
Okay. Good morning. Are you Jacqueline Young? And
Judge,
Mr. Lewis?
Judge, we had an agreement on this matter. Of course, it's an MTRP and a new law violation. The plea was for 5 years on both cases to run concurrently. After looking at it, when we did the plea paper, we realized that it was a significant difference in the credit that he has on the MTRP and on the new case. I was gonna ask, after seeing that and kind of talking to him about that a little bit, if I could get possibly 2 weeks so I could talk with him and as well as his mother. She's been pretty active in contacting. She's not here this morning, but.
Yeah, I mean, I'll do that. You'll have to redo the paperwork. I'll have to delete all that paperwork.
I'll go ahead and redo it.
And obviously, the fact that I don't know that, I mean, y'all can renegotiate, but I probably would not be inclined just because he doesn't have credit on a
Right.
new case that he's on to do that. But if you'll just explain that.
Right, I want him to totally understand what he'd be getting for
Sure.
parole-wise, eligibility and all that.
Okay.
It's not going to be a reduction in the offer or anything, Your Honor. He wants time to make sure
Sure.
he understands what he's
Okay,
saying.
we'll do a 2-week reset.
Okay, thank you.
Thank you. Mr. Parker, you've got Jennifer Bowles. Let's see, I need to send that back to you and delete all those, I guess? Not on the other one, okay. Good morning, are you Jennifer Bowles? Give me just a second here. And will Ms. Bowles waive the formal reading of the motion? Ms. Bowles, in cause number 18-29814, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation January 28th of 2019 for the offense of fraudulent use or possession of identifying information. That was a third-degree felony, and that was a 10-year deferred probation. Is that correct?
Yes, ma'am.
It alleges that you violated your probation. Count 1 alleges that you provided a urine sample October 24th of 2023 that tested, and October 25th, that tested positive for methamphetamines, amphetamines, and ecstasy. And is that true or not true?
True.
Count 2 alleges that you provided a urine sample January 25th of 2024 that tested positive for methamphetamines and amphetamines. And is that true or not true?
True.
Count 3 alleges that you failed to provide verification of attending the DROP program January 2nd, January 17th, January 20th, January 29th, and February 5th of 2024. Is that true or not true? Count 4 alleges that you're behind in your court-assessed fees as of January 25th of 2024 in the amount of $4,972.61. Is that true or not true?
True.
Did you enter your pleas of true to counts 1 through 4 freely and voluntarily? And did you plead true to those counts because they're actually true? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
Objection.
It's admitted. Is there any evidence that Ms. Bowles is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find that you entered your pleas of true to counts 1 through 4 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty. And at this time, find you guilty of the third-degree felony offense of fraudulent use or possession of identifying information. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. That will also run concurrently or at the same time with the Orange County case that you're currently serving any time on. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I've provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk to Mr. Parker. Good luck to you, ma'am. Thank you for being here, sir. Theodore Briscoe, 2 cases. There's no agreement on this.
No, I'll be there, I'll explain.
Okay. Good morning, sir. Are you Theodore Briscoe?
Yes, ma'am.
And Mr. Briscoe, in cause number 234535 is on probation for evading arrest or detention with the use of a vehicle. And in 236055 on probation for possession of a controlled substance.
Yes.
Motions to revoke those probation have been filed. Mr. Parker, announce.
Your Honor, just for the record, I went to see him at the jail and they told me he wasn't at the jail.
Oh,
So I didn't get to visit him and
Okay.
he was here. I got to visit him this morning. I told him that the court would probably give us more time to go over it if we wanted to, but I think we just need to go through the motion.
Without an agreement.
Without an agreement, I think he understands that. Also, there's a drug charge that hasn't been filed yet, just for the court's knowledge.
okay. And so, Mr. Briscoe, we can go through those motions today, get pleads of true or not true, or I can reset your case just a few weeks if you need more time to visit with Mr. Parker since he, okay. So let me get that pulled up.
And they're the same violations on both cases, Judge.
Can I get 36055 printed, please? Oh, no, that's okay. I gotta make marks on it. Thank you. It's just hard to do when I do them both on the computer. All right, in each of these cases that we've talked about, Mr. Briscoe, again, I have motion to revoke your unadjudicated probation. In 20-34535, the motion shows that you were placed on probation March 15th of 2021 for the third-degree felony offense of evading arrest or detention with the use of a vehicle, and that was a 5-year deferred probation. Is that correct? And in cause number 20-36055, I also have a motion to revoke your unadjudicated probation. Shows that you were placed on probation March 15th of 2021 for the third-degree felony offense of possession of a controlled substance, and that was also a 5-year deferred probation. Is that also correct? Each of these motions allege that you violated your probation. Count 1 in each of the motions alleges that you committed the new offense of possession of a controlled substance January 5th of 2025 in Jefferson County, Texas. And is that true or not true? Count 2 in each case alleges that you committed the offense of assault causing bodily injury to a family member January 5th of 2025. And is that true or not true?
Not true.
Count 3 alleges that you committed the new offense of interference with an emergency request for assistance January 5th of 2025. And is that true or not true? Count 4 alleges that you failed to provide verification of performing the community service hours as required. And is that true or not true? And count 6 in each case alleges that you were behind in your court-assessed fees. And is that true or not true? Did you enter your pleas of true in each case to counts 1, 4, and 5 freely and voluntarily? And did you plead true to those counts because they're actually true? All right, then I'm going to find in each of your cases that you entered your pleas of true to counts 1, 4, and 5 freely and voluntarily. Find those counts true. Find sufficient evidence in each case to find you guilty and revoke your probation, but I'm not going to do that today. I'm going to reset your case for sentencing. Mr. Nichols, does the state anticipate bringing witnesses for either of those cases?
Yes, Your Honor, I'll have to call witnesses to prove up the 2 that
Sure.
are pled not true to.
Do you anticipate that taking longer than an hour or so?
I do not, Your Honor.
Okay, we'll just set it maybe at 11 on a regular docket day. I will ask probation to do an updated pre-sentence report. Mr. Briscoe, obviously anything that you think is important for me to know, make sure and get that information to Mr. Parker. He will present it to me on your behalf when we come back.
Yes, ma'am.
All right, we'll see you back at sentence. Yes, it's unagreed. God bless you.
Come right here.
No, that's what Jake.
David James, Mr. Parker.
See if I'm right. Just this. No, not this one. See if I'm right.
Thanks for being patient this morning, Mr. Parker.
Mr. Millhouse was laughing at me, Judge.
Why? Because I put you last?
Yeah. 'cause
It wasn't really intentional. It
I
just
was
kind of
here
worked
first
out
and-
that way.
I was here first and he laughed at me.
You are always first, and I typically try to take notice of that. It just
Did you
didn't.
notice that the Jester was the best George we've ever had?
Good morning, sir. Are you David Wayne James?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment and the motion?
Yes, Your Honor.
Mr. James, in cause number 250522, you're charged with the third-degree felony offense of collision involving serious bodily injury from February 16th of 2025. And how do you plead to that charge?
I plead, no contest.
You either did it or you didn't do it.
I plead guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they've charged you with?
Yes.
All right. Then I have here on the computer in that case some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, sir.
Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Right, yes.
And it looks like the agreement that you've reached is for a 10-year term in prison, but that would be probated. You'd be on probation for 5 years. And is that your understanding of your agreement?
Yes.
Okay.
The other case is, if you can't read my writing, it's extended probation and safety relapse.
Okay.
No, you can read.
I guess the length of time in the probation is something that, obviously, the length of time on your probation, because it's even written on here, on this one, I can give you any amount of time in probation, so I don't have to follow that 5-year. If I give you the probation and sentence you to probation, the 10-year term in prison, probate it for any number of years, you understand that you'll be waiving your right to appeal. So the thing is, until I see an updated pre-sentence report and really see what's been going on, just on the face of this, it makes me have a little bit of pause because you're already on a felony probation and there's a new felony offense. And so I'm not sure that the length of time of only 5 years is something that I'm willing to go along with, but I'll take a look at it when we come back for sentencing. Do you understand?
Yes.
Your Honor, I've explained that to him, and I've explained to him that some courts don't even consider that. They automatically do it 10. But if you do everything you're supposed to do, the judge can always let you off probation early.
Correct. Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number one in that
No
case?
objection.
It's admitted. Is there any evidence that Mr. James is not competent?
No, Your Honor.
All right, sir, in 250522, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I am going to reset your case so that the probation department can do a pre-sentence report, give me an update, obviously, on the probation case, as well as more information on this offense, and then we'll come back later for sentencing. Now, in cause number 1523545, I have a second amended motion to revoke your unadjudicated probation. Shows that you were placed on probation November 13th of 2017 for the offense of burglary of a habitation, a second-degree felony, and that was a 10-year deferred probation. Is that correct? This motion alleges that you violated your probation. Count 1 alleges that you committed the new offense of possession of a controlled substance, February 3rd of 2025 in Jefferson County, Texas. And is that true or not true? Count 2 alleges that you committed the offense of possession of drug paraphernalia on February 3rd of 2025. And is that true or not true? Count 3 alleges that you failed to avoid persons or places of disreputable or harmful character, specifically by associating with past associates who are actively using illegal substances. Is that true or not true? Count 4 alleges that you provided a urine sample September 23rd of 2024 that tested positive for cocaine. Is that true or not true? Count 5 alleges that you provided a urine sample January 27th of 2025 that tested positive for methamphetamine. Is that true or not true? Count 6 alleges that you failed, nope, we're going to keep going. I want to know all of this if I'm going to consider leaving them on probation. Thank you, though. Count 6 alleges that you failed to abstain from the use of any and all intoxicating substances, including alcohol, and that you provided a urine sample on February 3rd of 2025 that tested positive for alcohol. Is that true or not true? Count 7 alleges that you're behind in your court-assessed fees as of February 3rd, 2025 in the amount of $1,689. Is that true or not true? Count 8 alleges that that doesn't really give me.
Yeah.
All right, I'm going to skip 8. Count 9 alleges that you failed to report to the probation department as directed on February 7th of 2025, and is that true or not true? Count 10 alleges that you were at a location other than your residence at approximately 11:51 p.m. February 16th of 2025. Is that true or not true?
That's true.
Count 11 alleges that you failed to submit to the alcohol or drug screening as directed February 11th, February 14th, and February 19th of 2025. Is that true or not true?
That's true.
Count 12 alleges that you committed that new offense of collision involving serious bodily injury February 16th of 2025. And is that true or not true? Did you enter your pleas of true to all of the counts except, let's see, 8, which is the one that I left out, freely and voluntarily?
Yes.
And did you plead true to all of those counts because they're actually true? I have here on the computer some documents that have your signature on them in this case as well. Again, did you go over these with Mr. Parker?
Yes.
Do you fully understand them?
Yes.
You understand if I follow the agreement that you've made with the district attorney that you would be waiving or giving up any right to appeal? And it looks like the agreement in this case would be for me to continue your probation, extend it for 2 years, and order you to the Safe B Relapse Program. Is that your understanding?
Yes.
State tenders number 1.
No objection.
It's admitted. All right, sir, I'm going to find that you entered your pleas of true to counts 1 through 12 minus 8 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. I'm going to reset your case, again, to get an updated report about this case as well as a report about the other case, and we'll come back at a later date for sentencing. All right, you can go back with the bailiff.
Thank you.
Yes, sir.
I thought that, yes, too. Well, it'll still be. So. I've had several of them like lately that have some of our administrators that I'm like, why don't you just do your probation, get it over with, and get off of it? I mean,
Darren Walker, Mr. Parker, 250256. You good over there?
hey, they've been pressure washing that, and it's hilarious because they don't know what they're doing. They did what Friday, somebody was there.
Good morning. Are you Darren Walker?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment?
You will, Your Honor.
Let's see. Are we going on count 1 only? The state jail felony? Not all the
It's
others?
a state jail felony, yes.
Right, yeah, but there's all
Yes,
these
we're going-
priors.
yes.
Yeah,
Count one would be the previous invading, Your Honor.
okay. Now, hold on a second. Let me get this pulled up right. Mr. Walker, the state is elected to proceed on count 1 only. It alleges that you committed the offense of evading arrest or detention with previous convictions from October 19th of 2024. It alleges you were previously convicted of evading arrest or detention October 21st of 2011. And how do you plead to that charge? And is that prior conviction true? Did you enter your plea of guilty freely and voluntarily? And did you plead guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Also, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection?
It's admitted. Is there any evidence that Mr. Walker is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of the state jail felony offense of evading arrest or detention with previous convictions. Sentence you in accordance with your agreement to a term of 12 months in the Jefferson County Jail under Section 1244 of the Penal Code. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Parker. All right? Good luck to you, sir. You can go back with the bailiff.
Thank you, Mr. Parker.
Thank you, Mr. Parker.